Thanks to everyone who's stayed the course with us. This is the last session of our update today, where I will be talking about the most recent UK IPO design consultation, which actually remains open for responses until the 27th of November. The context of this is the most recent EU design regulation, which has started a process of divergence from retained law following Brexit, and the fact that Brexit has created quite a complicated landscape for us in the UK in terms of design protection. So up on screen, you'll see the full scope of the consultation, which, as you'll appreciate, is fairly huge. It does seem like this time, following a number of design consultations that don't really seem to have affected significant change, that the government is serious about doing something fairly substantive to the UK design framework. Now, I'm not going to talk through all of these, you'll be relieved to hear, but I've picked out a few topics that I think are going to have the biggest impact on business and practitioners, and hopefully are also the most interesting. So the first thing that I'm going to cover is Section A, the proposals for searches, examination, bad faith, and potential opposition or observation for registered designs. So to take a step back, registered designs and designs in general are intended to protect the visual appearance of products or part of products. And there's slightly different scopes for different types of design rights, which is a topic we'll come on to. But broadly speaking, Section A seeks to tackle the problem of a proliferation of registered designs that are obviously invalid. And this is because the current UK regime has very limited examination and searching for registered designs. Effectively, you file your application, and as long as the pictures you file meet formality requirements, you'll get your registration through. And this leads to a lot of registered designs on the register which are quite obviously invalid. And invalidity for registered designs means if a design is not new, so not novel, or it fails to create a different overall impression on the informed user. So it might not be identical, so it survives a novelty attack, but it's not sufficiently original to be granted registered design protection. So the problem is that these designs, which could take the form of a copy of a third-party design, a design for a generic or well-known product, or a refiled application for a previously invalidated design, these design registrations can be used in takedown notices as well as in cease and desist letters. And whilst the registrations can be invalidated and the takedown notice is appealed or potentially even the subject of an unjustified threats claim, this does take time and money and places the burden on the innocent defendant to deal with the invalidly registered design. So I do see this in my practice, but I've put on screen some examples of UK IPO invalidity proceedings from this year. And as you'll be able to see, the registrations and the prior arts are virtually identical. And so this is the type of registered design that an enhanced search and examination procedure is sort of looking to weed out at an early stage, so that defendants don't have to go to the expense and incur the time involved in actively trying to invalidate these designs, presumably once they've received a cease and desist or a takedown notice. So the first proposal relates to search and examination before registration. So there's a number of options there. One which the consultation has labelled as option 0 is to do nothing. And that has effectively been discounted by the government, though they've asked for any responses from people who think that actually, no, it's perfectly fine as it is and we should do nothing to the search and examination process. But really, it seems like the government is between two proposals. So option 1, to allow powers for the registrar to carry out a search at their discretion. So not every design will be caught by this. The registrar will be given the discretion if they see a design that they think, oh, that obviously doesn't look new or doesn't have individual character, they can then carry out a more formal search for any existing registered designs that they think would render the new application invalid. And option 2 is a more complete two-stage system where every design is first partially registered without a search, and then following that initial registration, if the design ever wants to be enforced, a full search and examination is required. So this mirrors the system they have in Australia. And stage one effectively is the current registration process, so quick and cost effective, but all that gets you is a design which is partially registered or registered at risk. And so you would need to go to stage two, and make a request for further examination for an additional fee, and there will be obviously a time lag involved in that search and examination. Interestingly, the proposal is that that fee could be paid by the proprietor or by a third party. So, for example, if you have your design that is partially registered and you send a cease and desist, the person you send it to could request that your design is examined if they think that that's likely to render it invalid. Another thing to flag here is that the government have said that the current capabilities mean that it's likely that any searching is going to be for novelty only and not for a lack of individual character, because obviously that would cast a wider net to designs that aren't just identical or near identical. Though they do make the point that there may at some point in future be an AI tool that would allow for more comprehensive searching in a proportionate way in terms of cost and time. But these are the two proposals, option one and option two, that are really at stake. An additional means of weeding out these obviously invalid applications would be to introduce a specific bad faith provision in UK design law, presumably one that would mirror the bad faith provision in trademark law. And those would be, the proposal at present is to only include bad faith as a ground for the registrar to object to an application, and either if it was a well-known product, if, for example, the application was for another company's photographs of their own product, or an application which has refiled previously invalidated designs, or anti-competitive applications more generally. The slight issue with a bad faith ground is it's difficult to see how much further it would go than the existing invalidity grounds. And if it does go materially further than those grounds, what are the boundaries of that bad faith provision? And we've seen in trademark law that there's been lots and lots of litigation over what bad faith means in a trademark context. The latest big piece being the Supreme Court decision in Skykick, and that really hasn't given the clarity that everyone had really been after. So I question the value of a standalone bad faith ground in design law. And then the last piece to the searching and examination proposals are the proposals for an opposition or observation period. So currently there is no ability for third parties to oppose or provide observations on registrability. The only means that they can attack a application is for an invalidity attack post-registration. So here there are a number of options. Option 0 to do nothing. Option 1 to introduce a post-registration opposition period similar to the trademark opposition period, in that it would be for 2 months, but it would be post-registration rather than pre-registration. And the government considers that that doesn't really offer any advantage over the current invalidity process, so that seems unlikely to get off the ground. But option 2 would be a pre-registration opposition period for designs which would more closely mirror the trademark process. Or option 3 to introduce a pre-registration observation period. So a party would submit an observation to the IPO, and it would then be up to the registrar as to whether they wanted to pick that up and run with any observation that had been submitted. And as the consultation recognises, really there's going to have to be a combination of these options to tackle the problem of invalid designs on the register. And so of those options, my own view is that the best combination would probably be a limited search and examination at the IPO's discretion, combined with a pre-registration observation period. So effectively, that means either the registrar picks something up, or a third party can flag something to the registrar and hope that that triggers the registrar to use their discretion to run with an invalidity argument on novelty or lack of individual character. Though I think I would be open to the more thorough two-stage registration system that would apply to every application. But my only reservation with that is that the design system is already, I think, underutilized compared to other registered IP. And anything that makes the process more complicated or expensive or time-consuming should really be approached with caution if we're wanting to encourage more people to seek registered design protection. So from registered designs, pivoting to unregistered designs, which the consultation also covers. So one of the big parts of the consultation is the proposals to simplify unregistered designs. And the problem here is that there is a complicated web of protection for designs in the UK. And that can include registered designs, which are national registrations or Hague registrations designating the UK, UK unregistered design right, supplementary design right, which mirrors the EU unregistered design right regime, and copyright protection for certain designs. And so that graphic there is a fairly accurate visual representation of what my brain does when I'm asked to work out how a particular product is protected under various unregistered design regimes. So of the discounted options that the government has already considered, they're not going to abolish SUD and just retain UK unregistered design right. They're also not going to abolish unregistered designs altogether and extend copyright protection. And they've also decided that they're not going to make no changes and just improve guidance on how designs can be protected. So there is going to be some change here. That said, they're still listed as option 0, the option to do nothing, though, as I say, that has been apparently discounted by the government. So the two main options that are in the consultation are to retain supplementary unregistered design right and abolish UK UDR, and they describe that as maximum simplification. So you have one right that everyone already knows how it works and that mirrors broadly the EU regime. The second option would be to create a consolidated unregistered design right, and they describe that as maximum protection. So you don't lose UK UDR, you just incorporate the provisions under that regime into a single consolidated regime. And within that option 2, there are various sort of sub-options. So you could harmonize certain provisions, but retain separate SUD and UK UDR, or you could create a single consolidated right, which has a slightly different scope of protection for certain things that are protected slightly differently under the current regime. So, for example, SUD protects surface decoration and UK UDR doesn't. It only protects shape and configuration. Or you could create a fully consolidated right, either along the lines of SUD, UK UDR, or more likely somewhere in between the two. And it seems from the later part of the consultation that third option, creating a fully consolidated right that sits somewhere between the current regimes, is likely where we're going to land on this. So in terms of what the government thinks that consolidated right should look like, at minimum, they want to consolidate the term and qualification requirements. So at the moment, the proposed term for this new consolidated right is 5 years. So that sits somewhere between the 3-year period from disclosure granted to SUD and the 10 years from first putting a design on the market, or 15 years of first documenting a design for UK UDR. There are other options, as you can see, they're 3 years, 5 years, 5 years plus a 5-year license of right, or 10 years that are all in the consultation the government is seeking views on. But at the moment, their preference is for a 5-year term. And qualification requirements, their preference is basically to adopt the same regime as for supplementary unregistered design right, which is qualification by disclosure in the UK, though the scope of that qualification is also part of the consultation, which I'll come on to. Broadly speaking, the government's view in the consultation is that the SUD rules should prevail for most things. So for ownership the rights conferred, the test for infringement, and how we deal with spare parts, their preliminary view is that we should just adopt the SUD rules and do away with the slightly more complicated UK UDR rules for each of those. The one open question is whether protection should be afforded to component parts of complex products which are not visible in use, as those are currently excluded from SUD. So it would be a significant restriction if we were to just simply adopt the SUD rules for everything, including component parts. So as I mentioned, whilst the current preliminary position is that we should adopt the SUD regime for how unregistered design rights are first come into being and are granted protection, i.e. disclosure in the relevant territory, the consultation also asks whether the current regime of unregistered design rights, or SUD as it is at the moment, only applying to designs which are first disclosed in the UK, ought to be broadened. And this is a result of Brexit, because previously you would have had a community-wide design right that would have applied to any disclosure within the community when the UK was part of the EU community. So of the discounted options, we're not going to open up the problem with the EU and seek reciprocal recognition of disclosure. That is off the table. And we're also not going to say that any disclosure anywhere abroad can give rise to SUD. So the options that are on the table: do nothing, stick with the current regime of requiring disclosure in the UK, first disclosure, I should say, in the UK. Option 1 would be to unilaterally recognise simultaneous disclosure in law, because at the moment it's a bit of an open question as to whether a simultaneous disclosure in the UK and EU would, for example, trigger both the EU unregistered design right and the current SUD, and what that actually means in terms of what is a simultaneous disclosure. Does an online disclosure that targets both audiences qualify? The second option would be to introduce a grace period for unregistered design. So as long as you have a disclosure in the UK within the relevant grace period of a first disclosure elsewhere, that could give rise to SUD, though that seems slightly overcomplicated. Option 3 would be that SUD is created following first disclosure anywhere in the EU, which has come to the attention of relevant trade circles in the UK. So strictly speaking, your disclosure doesn't need to be in the UK, but it still has to be of a public enough nature that it comes to the attention of people in the UK, or the creation of SUD following first disclosure anywhere in the world, but which again has come to the attention of the relevant trade circles in the UK. So I think the concern here is that any option other than do nothing runs the risk of creating a degree of asymmetry with the EU regime, because the EU regime only grants protection to disclosures in the EU. We think, and I say we think because the recent EU design regulation, which came into force in May of this year, has slightly changed the provisions around creation of unregistered EU design rights. So it isn't actually entirely clear, and I don't think we'll have clarity until a case comes to the ECJ as to the specific requirements for disclosure in the EU. There are people who think that a disclosure outside the EU, but which comes to the attention of trade circles in the EU, would qualify for protection, especially now that the design regulation has been amended. So all that goes to say, I don't think we should be overly concerned about asymmetry. We currently have asymmetry in terms of exhaustion of IP rights, and that was consulted on, and we decided that no, we're quite happy with an asymmetrical regime where if something is first put on the market in the EEA, it's considered exhausted in the UK, but if something is first put on the market in the UK, it's not considered exhausted in the EU. We've learned to live with that. So the last topic I wanted to cover was again, it's on unregistered design rights, but specifically the overlap with copyright. So the problem here is that certain designs could be protected by copyright, but the scope of UK copyright protection in particular is uncertain, especially for works which might more traditionally be protected or thought of as designs. And there is already significant divergence between the EU and UK on this, and anyone who listened to Lionel's talk will be aware of some of those issues. But broadly speaking, the EU grants broader copyright protection than the UK, significantly broader copyright protection, especially for sort of non-traditional works like these that might more ordinarily be considered as designs. And at the moment, to some extent, this is counterbalanced by the fact that we have a longer national UK UDR and there aren't equivalent design rights in all EU member states. But if we get rid of UK UDR and have a shorter lived, consolidated, unregistered design right, we do run the risk of being put further out of step with EU countries and the unregistered protection afforded to designs. So in terms of the consultation itself, option one is to do nothing, make no changes to the current copyright system. And to my mind, rather surprisingly, that is the government's preference. Option two would be to amend copyright legislation, and that would be to remove works of artistic craftsmanship from copyright protection. And works of artistic craftsmanship is usually what you would try and shoehorn what would otherwise be protected as a design under. In our closed list of copyright categories, you have to fall within one of the categories in order to get copyright protection in the UK. And so the proposal there would just be to remove that as an option, remove works of artistic craftsmanship, basically with the effect that most designs are then not going to be afforded copyright protection. The alternative would be to provide a definition of works of artistic craftsmanship. And again, that could either be an expansive definition or quite a restrictive definition, or to provide a new definition of originality in relation to design articles. And again, that could go either way in terms of allowing more design articles to fall within the scope of copyright protection or fewer. The third option, which really is more sort of tinkering around the edges rather than tackling with the issue head on, is to update some of the copyright exceptions. So we did used to have a shorter term granted to industrially manufactured items, which fell within the copyright regime, but that fell within section 52 of the CDPA. That was done away with because it was held to be incompatible with EU law pre-Brexit, but we could introduce that again if we're saying that, well, we're comfortable to grant copyright protection to a broad scope of what would otherwise be designs, but not for the full long term of copyright. Or we could introduce spare parts exception and harmonize with the equivalent designs exception, or we could amend section 62 of the CDPA, which is the panorama exception, to allow works of artistic craftsmanship to be represented in new artistic works, i.e. reducing the scope of works of artistic craftsmanship. But I think on this point, which I think hasn't been given enough attention on the consultation, the government says that it's quite happy with the current copyright position. They say that they acknowledge that there remains uncertainty around the boundary and extent of overlap between copyright and designs, but that recent developments in case law and the lack of a clear alternative approach means that making changes to the copyright regime is not their preferred option at this stage. So I think it's worth revisiting some of that case law that the government is apparently happy with. So on screen, you can see images of works that have all been the subject of copyright litigation. So you've got a sofa set that was the subject of Hensher and Rest-A-While, you've got Brompton Bicycle, Water Row, a rowing machine, the fabric from Response Clothing, and one of the helmets that was the subject of the Lucasfilms and Ainsworth case. So looking at those cases, the most recent one was the Water Row case. And in that case, the court was left to interpret what works of artistic craftsmanship meant in light of the underlying ethos of the arts and crafts movement from 1850 to 1920. And the reason for this was that works of artistic craftsmanship was first included in the 1911 Copyright Act. So that was the context in which we had to interpret the meaning of those words. And also Hensher, which is the Hensher and Rest-A-While, the sofa set case, which is, I think it's fair to say, a fairly impenetrable House of Lords authority from 1974, in which the sofa set was held not to be a work of artistic craftsmanship. the Lucasfilm series of cases where ultimately work of artistic craftsmanship was dropped on appeal, and which did conflict ultimately with a parallel US decision which held that the helmets could be granted copyright protection in the US, and which, as Lionel flagged in his talk, probably wouldn't be decided the same way again today, given the EU line of cases. In Wateroa, Bonds was also relied upon, which is a New Zealand High Court case from 1994, which formulated a test later applied in the English courts, which essentially was that the creator of a work of artistic craftsmanship must be an artist and a craftsman. And then Cofimel and Brompton Bicycle, which are CJEU decisions, which are effectively incompatible with the UK's closed list copyright system, because in those cases, as long as the originality requirements were met, you got copyright protection. You didn't have to fit into a particular category or have something that had particular artistic merit. And then Response Clothing, which was the previous UK case on this, which held that a fabric was a work of artistic craftsmanship, but noted that the Lords in Hampshire would have disagreed, which arguably conflicts with Court of Appeal authority that says, even if you can't make sense of a House of Lords decision, you have to apply it in such a way that gives effect to the ultimate conclusion, which in that case was that copyright would not have subsisted in the work in question. And that case was also subject to appeal until the appellant went into administration. So in my view, it's not particularly good authority. So given this long patchwork of cases, I'm not convinced that we do have a solid basis to understand what copyright protection is afforded to designs. Added to all of that, we have the rather impenetrable sections of the CDPA which govern the overlap between registered designs and copyright. So section 236 of the CDPA states that where copyright subsists in a work which consists of or includes a design in which design right, that's UK UDR, subsists, it's not an infringement of that UK UDR to do anything which is an infringement of the copyright in that work. So it's basically saying copyright takes precedence when it subsists. And section 51(1) of the CDPA says it's not an infringement of any copyright in a design document or model recording or embodying a design for anything other than an artistic work or a typeface to make an article to the design or copy an article made to the design. So you might have a design document, which the document itself is going to be a copyright work. It's going to be a literary work or a graphic work. But if the thing which it represents, the design which it represents, is not itself an artistic work, i.e. a work of artistic craftsmanship, then you can't sue for infringement of the copyright in the design document. You have to rely on any design right. This is all very complicated. If it makes your brain hurt, you're not alone. It makes my brain hurt every time I have to think about it. But it goes to show that we are sort of at odds in the case law and in the statute in terms of trying to draw some sort of line between copyright protection and unregistered design protection. And I think it's been done in such a way, in such a patchwork way, with so many different influences, that I think it really would be a good opportunity now to grasp the nettle and actually do something conclusive to take a position on what we think copyright should cover. So the likely outcome from this consultation and the elements that I've covered today, I think we are going to get some form of enhanced search and examination procedure for registered designs. The question what that looks like, whether that's at the IPO's discretion, a blanket procedure for all designs, and whether we're looking at novelty or novelty and individual character. I think we are probably going to get some form of opposition or observation procedure. My view is that an observation procedure would probably be enough. I don't think we need to add the complexity and the delay in a series of different opposition procedures, but remains to be seen where the government lands on that. And we're also going to see some degree of simplification of unregistered designs, most likely to result in a single SUD style right with a slightly extended term. And we're also, I think we're going to see the qualification criteria for SUD or that SUD style right to expand to include some disclosures abroad. But I think, unfortunately, unless the government gets a wave of responses to the contrary, we are unlikely to get any big changes to the copyright regime. Though if you feel as I do, I would strongly encourage you to include that in your response to the consultation, because I do think it would be a missed opportunity not to deal with the overlap conclusively at this stage. And the consultation does remain open until the 27th of November, so there's still plenty of time to put your response in and have your say. So that was the end of my rather whistle-stop tour through those provisions of the consultation. If there are any questions, I would be very glad to answer them.